If you own a firearm in this country, any firearm, what happened at the Supreme Court level recently is not something you can afford to ignore. I'm not talking about a minor procedural ruling. I'm talking about a shift in how the highest court in the land is thinking about what the government can and cannot ban. And the line they just moved, it runs directly through your gun safe. Stay with me, because by the end of this video, you're going to understand exactly what changed, why the headlines are missing the most important part, and what you need to do or stop doing right now. I'm a Second Amendment attorney. I've spent years in the weeds of firearms law, reading opinions, tracking ATF rulemaking, watching courts quietly rewrite the rules that govern what you can legally own, carry, and use to defend yourself. And I'll tell you this directly, most gun owners don't hear about these shifts until after they've already made a mistake. My job is to make sure that's not you. Here's why this matters right now. For decades, courts operated on a fairly flexible standard when evaluating gun regulations. The government would argue public safety. Courts would weigh that interest against your rights. And in most cases, the government had a wide lane to work with. Then came Bruin, the 2022 Supreme Court decision that fundamentally changed the framework. Under Bruin, the government can no longer just point to public safety and call it a day. They have to show that a modern gun regulation is consistent with the historical tradition of firearms regulation in this country going back to the founding era. That was a massive shift. Gun owners celebrated, and rightly so. But here's what most people missed. Bruin didn't end the legal war. It changed the battlefield. And the fight's playing out in the lower courts right now over what specific weapons are legal to own, who can legally possess a firearm, and what features make a gun too dangerous for civilian ownership. Those fights are still being decided, and the outcomes are not always going in our favor. Which brings us to what just happened. The Supreme Court recently signaled through a ruling and through its willingness to let certain lower court decisions stand that the Bruin framework does not automatically protect every type of firearm or every type of owner from every type of restriction. Let me say that again more plainly. Just because Bruin requires historical grounding doesn't mean every gun regulation automatically fails that test. Courts are finding historical analogs, they're getting creative, and some of those arguments are holding up. What that means for you is this: the legal ground you thought was solid after Bruin may have more cracks in it than you realize. Here's the part most gun owners get wrong. They heard Bruin and thought, the Second Amendment is locked in now. The government can't touch my guns. Any new restriction is automatically unconstitutional. That is not how this works. The Bruin test requires historical grounding, but history is being interpreted by judges, and some of those judges are finding history that supports restrictions on specific classes of weapons, specific types of modifications, and specific categories of people. The AR-15 debate is the clearest example. Multiple federal courts are still wrestling with whether rifles like the AR-15 are protected under the Second Amendment, or whether they fall into a category the government can restrict as dangerous and unusual. Post-Bruin, the legal argument has gotten harder for the government, but it hasn't disappeared. And the Supreme Court has not definitively resolved that question. That's the open loop you need to understand. The fight isn't over. It's in a different phase, and the outcome of that phase depends heavily on which cases reach the Supreme Court next and when. But here's the catch, and this is the part that should concern every responsible gun owner watching this. The legal uncertainty itself creates risk. Even if you believe correctly that your rifle, your magazine, your suppressor, your pistol brace is constitutionally protected, the law in your state or your circuit may not reflect that yet. Federal circuits are split, state laws are patchwork, and the gap between "I think this is legal" and "a court has confirmed this is legal" is exactly where people get charged. You don't beat a felony charge by being right about the Constitution. You beat it by having a lawyer, a legal strategy, and ideally by never being in that situation in the first place. Let me reframe what's actually happening here, because the mainstream take on this is almost always wrong. People frame Supreme Court rulings as final answers.
Win or lose, done. That's not how constitutional law works in practice. A Supreme Court ruling is more like a new set of rules for a game that's still being played. The lower courts are the ones playing the game, and until the Supreme Court steps in again and again to correct the ones who are misapplying the rules, those misapplications have real consequences for real people. What the recent court activity signals is that more cases are coming. More showdowns over specific types of firearms, specific regulations, specific rights. And the direction those cases go depends heavily on how gun owners, gun rights organizations, and frankly, how attorneys like me push back in court. The legal war on the Second Amendment did not end with Bruen. It entered a new phase, and that new phase is happening right now in courtrooms most people never hear about. So what do you actually do with this? 3 things. First, know the law in your state specifically. Federal constitutional trends matter, but your immediate legal exposure depends on what your state legislature has passed and what your circuit court has upheld. Those 2 things may not match what the Supreme Court's direction implies. Until they do, you live under the law as it exists, not as it should exist. Second, document everything. If you own items that are in any kind of legal gray zone, and after everything I've described, you should be asking yourself honestly whether anything in your collection qualifies. Keep receipts, keep records, know where you bought it, know when the law changed, and know whether you qualify for any compliance windows or grandfather clauses. Third, stop relying on online forums for legal guidance. I say this with respect. The guy in the comments who tells you something is definitely legal is not going to be at your arraignment. Get actual legal information from actual attorneys who specialize in firearms law. The 5 minutes you spend asking a question online is not worth the felony charge. Let me bring this together quickly. Bruen changed the constitutional framework. That was a genuine win, but it did not end the fight. Courts are still applying that framework unevenly. The Supreme Court has signaled that more specific questions about specific weapons, specific regulations, specific rights remain unresolved. The legal uncertainty that creates is real, and it falls on you to navigate it carefully. The headline says the court shifted the line. What that actually means is the line exists, it moved, and it will move again. The question is whether you're paying attention when it does. Here's the bottom line. Constitutional victories matter. Bruen was real. The momentum is real. But legal protection in theory and legal protection in practice are 2 different things. The gap between them is where good people get charged, convicted, and lose their rights permanently. Know your state law. Know your specific situation. And treat legal gray zones like the live wires they are, with caution, not confidence. If this video gave you clarity on something you weren't sure about, or if it raised a question you didn't know you had, that's exactly what this channel is here for. Hit subscribe, turn on notifications, because these legal developments don't wait for you to catch up, and I'm not going to let you fall behind. Stay informed, stay legal, stay armed, and remember this: your rights are only as strong as your understanding of them.